court, and if the court were to permit, Lady, we would be requesting that Mr. Ayora makes submissions on our behalves.
How much time?
10 minutes.
10 minutes.
At the maximum.
Yeah.
Any objection to that submission by Mr. Awora?
Yes, we have not been served with any document. So
they don't need to file any document.
We don't know what they want to submit.
Counsel, they don't need to file anything.
Very well.
I expect they are saying something about something from the victim, like victim impact, which they are allowed to do.
This were before you, Lady, under Section 9 of the Victims Protection Act. Thank you.
Any objection?
No.
Okay.
Most obliged.
So we'll start with, of course, the one making the application. No. So you let me know when there are 5 minutes to 5 minutes to the time. Okay, we'll start with the.
Your Ladyship, we have 3-pronged attack to this application. So I will start with the substantive law and proceed with the procedural law and the application affidavit. And after that, I will hand over to Mr. Peter to deal with the reply affidavit and also the authorities.
Remember, if you're handing over to someone, your time is for 5 minutes.
Yes.
Okay.
And lastly, Mr. Sagana will reply the state submissions. Your Ladyship, this application is made pursuant to the provisions of Section 123 of the Criminal Procedure Code. I'm not sure whether it is on record. It's 123 or 124. But I want to correct it in case it is 124 to 123. 123. And Article 20, Sub-Article 3, 5, 4, and Article 21, Sub-Article 1, Article 22, Sub-Article 3 and 4, and Article 49, 1H and 52A of the Constitution of Kenya 2010. I will proceed with prayer 2, which is that the Honorable Court be pleased to release the applicant on bail or bond on such reasonable conditions as the court may determine. And number 3, that this Honorable Court be pleased to issue such orders as may be fair and just to secure the applicant's constitutional right to be released on bail or bond pending the conclusion of his trial. The application is predicated upon the affidavit of Zachary Obado, the accused person herein, and on the following grounds. Number 1, the offense of murder is bailable under Article 49, 1H of the Constitution of Kenya 2010. 2, the applicant has a qualified constitutional right to be released on bond or bail on reasonable conditions. Number 3, the applicant has a qualified constitutional right to be presumed innocent until the contrary is proved. And number 4, the applicant will avail himself to court as and when required to do so until the matter is concluded. Number 5, the applicant shall abide by any conditions that shall be set by this Honorable Court as a prerequisite to grant or bail or bond. Number 6, the applicant shall not interfere with witnesses in this matter and any investigation which should be carried. And number 7, the applicant has cooperated with the investigation so far. Now, we adopt the affidavit of Secretary of Obado, which is in 19 paragraphs. It was sworn on 24th of September 2018, and we emphasize paragraph 7, paragraph 8, paragraph 10, 11, of the said affidavit. Your Ladyship, cognizant of the fact that Kenya is a constitutional democracy governed by the rule of law, we take the lead by invoking the provisions of Article 49, sub-Article 1H. And being aware that the Constitution of Kenya, aforesaid, does not provide for the procedure in such an application, we invoke the provisions of Section 123 of the Criminal Procedure Code. We reiterate that every accused person has equal protection and equality before the law. We are sensitive of the fact that the Constitution of Kenya at Article 165, sub-Article 1B, and Article 49, sub-Article 1H, together with the Criminal Procedure Code at Section 123, bestows upon you the jurisdiction to enforce the Bill of Rights. As crystallized in Chapter 4 of the Constitution of Kenya. In addition to the Bill of Rights as enshrined in the Constitution, we are also cognizant of the fact that the international instruments which have been ratified by Kenya and therefore form the part of the laws of Kenya by dint of the provisions of Article 2, sub-Article 5 of the Constitution. That deals with unalienable rights of human beings and are contained in the Universal Declaration of Human Rights. 1948, the National Convention on Civil and Political Rights, the International Convention on Social, Economic, and Cultural Rights, 1966, and this form the general rules of international law, and they form part of the laws of our land. By dint of the provisions of Article 19, sub-Article 3A, the fundamental freedoms in the Bill of Rights belong to each and every individual, and they are not granted by the state. And in applying the Bill of Rights, the High Court shall adopt the interpretation that most favors the enforcement of the rights of an individual. And in interpreting the Bill of Rights, the court is enjoined to promote the values that underlie an open and democratic society. Under Article 21 of the Constitution, it's the fundamental duty of the state and every organ thereof, including this court, to observe, respect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. And we urge your leadership to give effect to those constitutional provisions which are so sacrosanct that cannot be wished away by the whim of the state. Having said that, I wish now to underscore the principles upon which this court and in a high court grants bail. And that the fundamental principle of bail is to ensure the attendance of the accused person at his trial. So the question this court will ask itself is the accused person capable of attending his trial? Or is he likely to evade justice? person has undertaken to abide by the conditions that this court will grant him and attend not only the hearings but also such mentions. Or any other order that this court might deem fit. But the grant of bail is not a matter of course. It is discretionary. And we hereby invoke your discretion. To grant the applicant bail. In granting bail, the court should take cognizance of the fact that the amount of bail should not be more than will probably secure the attendance of the applicant. And that amount should never be so large as to amount to denial of justice. I'm aware of the fact that each case must be treated having regard to its peculiar circumstances. The applicant has been tried, convicted, and executed by the media. And we urge your leadership in considering this application to discount the innuendos, the rumors, the half-truths, the falsehoods that have been peddled by the media. In good time, the correct evidence will be before you come the trial. Other minor considerations that your leadership should look into is the nature and severance of the offense, the severity of the punishment involved, the strength and the evidence in support of the charge, which has so far not come out. And lastly, whether there exists some compelling reasons for refusing the grant of bail. If there are such compelling reasons, should be brought before this court by way of affidavit. Which enjoins the deponent to be cross-examined on the contents thereof. Otherwise, your leadership should also ignore and discount stock allegations. Stock allegations which the prosecution normally, the mundane investigations are not complete. The accused is likely to interfere with witnesses. Those are stock allegations that the prosecution normally comes up with. Unless verified by affidavit, they should be ignored. Article 50, sub-article 1A of the Constitution provides that each accused person is innocent until the contrary is proved. If this presumption of innocence is to have any meaning at all, an accused person should not be deprived of his liberty, save in very exceptional circumstances, which is not the case. With a few remarks, I rest my submission and hand over to Mr. Beta.
Your Ladyship, probably one thing that we need to know about Article 49 1H is that once an accused person has been brought to court, his right to bail is actually self-activating. And once it's self-activating, it is supposed to be the prosecution who are supposed to actually file any papers to indicate that they want to object. So they should be coming with that in the first instance. But in this particular case, we have filed. We burnt the midnight oil and served them yesterday. Now, Your Lordship, they needed to come to this court with compelling reasons, apart from that application. And then compelling reason must have a definition. In our law books, we do not have that definition. It is not in the Constitution. It is not provided for. So then what do we use? We must then rely on the dictionary, and that's the Oxford or the Thesaurus. And they both define something compelling must be something that is so strong, so forceful, so convincing that the court, when presented with such, cannot ignore. I must say that the prosecution, with this affidavit that they have brought to court today, they have missed their target. And if they have missed their target, Your Honor, then that compelling reason is absent. And therefore, this particular act then turns, it evolves, it takes a life of its own and becomes a total right. So we are feeling threatened at this particular moment because of this affidavit. They are bringing allegations, so many of them. And that is why we must invoke Article 22 of the Constitution, which says that the moment we feel that our rights, fundamental rights, are being threatened, then we shall come to court. And this is what we have done. We have made an application. And once we come with this to you, Your Ladyship, that is when you look at it together with Article 165. And then when you've done that, my lady, you will realize that what they have told you today in the affidavit is totally, does not make sense. And by doing that, when they bring such an affidavit, Your Honor, it kills Article 19. It destroys Article 19, whereby now, if they don't have compelling reasons, they are interfering with our rights. They are interfering with our rights. And these rights do not belong to them. They do not belong to the state. They belong to an individual. This particular Article 19 then fades into Article 20. And Article 20 is clear, my lady, that we are all bound, including the prosecution that is making this affidavit and the officer. They are bound by this, providing the fundamental rights. They must recognize them. And once they recognize them, Article 21 then says they must start by wanting to enforce them, which is not the case here. They are trying to terminate that fundamental right. You can only be the one who can help us in this situation, right? The accused person is before you, my lady, and has pleaded not guilty in this case. The moment he pleads not guilty, then Article 50 comes into play, because then the presumption of innocence must come into play. It was not put there for no reason at all. It was put there for a reason. So that the moment he has pleaded not guilty, his life must go on. We must not then wait for the allegations to be over. His life must go on. This presumption of innocence also helps us to prepare for the case so that he can be able to rebut whatever the police have brought, whatever the prosecution brings. This presumption of innocence under the same article also brings out the issue of him being ready to prepare for his trial. So how do we prepare for the trial? We must have a free mind. We must have a free atmosphere. He must be able to consult his lawyers as and when he wants and whichever place. All these instruments must be granted to him so that he can also feel that he has been treated fairly. But when they bring this affidavit, you can see from the word go that this is not what they intend to do. Now, my lady, the same thing is in Article 28 of this Constitution. Article 28 is so clear that the accused person has inherent dignity. Inherent dignity. If it was not important, it could not have been put there by the legislature. So when we are talking of dignity, what are we talking about, my lady? As my learned senior has indicated, the accused person has been tried in public and is at this bottommost. That cannot be dignity. Actually, it kills his spirit when he sees all these things. And this article is there to protect him. So if we do not recognize his dignity as well, then how does he come and fight in this case? And dignity is not only his status. Dignity is also in the face of it. Because today, if this accused person was to come to trial every day, escorted by officers in blue and green uniforms, and he's in handcuffs, where is his dignity? If he has to be taken by bus every day with the one we call the moody hoppers on a daily basis to and fro, where will be his dignity? But when he comes from his house, he has showered, spoken with the family, he has had his prayers, then dignity begins to come in. And my lady, when we start with the equal footing, forget about the press, and forget about the social media. We come here because we know in this court, we start on equal footing. That is dignity. My lady, this affidavit that has been given here today, I will ignore all the other parts and then go straight to article number 10. Paragraph number 10. This affidavit has been signed by Inspector Clement Mwangi. That investigations herein is complex and involves multiple suspects covering a wide range of issues and suspects spread over a wide area. My lady, how is that a compelling reason? That they are having a problem and finding this case to be complex is not the problem of the accused person. Not today, not ever. It is their problem. And for them, these are not their fundamental rights. They belong to the accused person, not the state. So if they're having a problem with this, let them not use as an excuse to say that it is complex. So what, my lady? So what? And then paragraph 11 comes in and they tells you that the investigation reveals that the state has a very strong case against the accused person and his accomplices. The accused person has denied the charge before you, and that is why we are saying they do not have a strong case. So if they say they have a strong case, we say they do not have a strong case, that is where it ends, and that's where you take the probability. But first, it must be visited with a favor to granting what favors the accused person, as is said in Article 21. But then again, for them to even bring this allegation or saying this, that they have a strong case, that is a matter of evidence. Then it is not attached in this affidavit. What is strong about their case? This shall be tried in the case, in the trial itself. That is when we shall know whether they have a strong case or not. That then today cannot be a compelling reason. Please ignore it. And then they tell us that the accused person in paragraph 13 has been charged with a capital offense. Isn't that why we are here? We know it. You don't even have to put that in the affidavit. We know that it is a capital offense. But then what does Article 49 say? Article 49 is so clear that any accused person or suspect who is brought to court shall be entitled to bail. And compelling reasons must be given. So when you tell us that, when we are told, my lady, that they have a strong case and it's a capital offense, how is that a compelling reason? Paragraph 14 tries to take the chunk of that affidavit. And they tell us that the investigations are not yet complete. That they'll be proceeding towards Migori and through and fro. What are we doing in court today? Why did they bring the accused person in court today if they have not completed the investigations? Why did they rush to bring the accused person to court today if it's not pressure from the public? So when they tell you the investigations are not complete, how is that again the problem of the accused person? Because when they have brought him here, the presumption is that they have finished the investigations. So let us take that avenue, that they have completed the investigations. Anything else they are saying is just blanket to add to the meat of the application. We are being told in that same paragraph that the 3 abductors or hitmen are still at large. They have not told you how these hitmen are related to the accused person. How those 3 men being out there, who we don't have their names here today, or know who they are today, can be a compelling reason against the accused person. But then they try to mix it with a little bit of of cheekiness, if I can say, my lady, and say that the accused person has a lot of influence in Migori by virtue of his position as a governor. Yes, he was elected by more than 350,000 people. Yes, he has influence, but that influence is of a political nature, not of a case like this, not on people who are witnesses in this case. They need to differentiate that his influence is based on politics and nothing of this kind. They need to show you further how his influence then is going to affect this case, and that his being inside shall cure it. Because influence is influence inside or outside, but they must put some meat to it and show you how it is going to affect it. And being a person of influence is not a problem. And that is why, my lady, I must invite you to have a look at Richard Alden versus Republic. That is case number 48 of 2016. I will also invite you to look at Dwight Sagarai versus Republic. That was case number 61 of 2012. Roger Sinzioka versus Republic. Miscellaneous application number 13 to number 18 of 2018.
You have 5 minutes.
Yes.
And these ones you are quoting, have you brought
yes,
them here?
they're all there.
The last,
all those ones were...
the
yes.
last one was miscellaneous?
Miscellaneous application number 13 to number 18. There were various applications of 2018. In Richard Alden versus Republic, this matter, my lady, was before you. And all those sorts of allegations were brought in, whereby they were saying the accused person was a person of influence. But my lady, you dealt with that properly and indicated that that influence needed to be proved, and to what extent and how it was going to affect the case. It is the same with Dwight Sagarai, who was working for the Venezuelan embassy, and what was said in that case. Influence must be shown, and they must show how it has affected this case, how it is going to affect, and whether that influence will be able to be used in any way to exercise to the witnesses. In the miscellaneous application that I've told you, Justice Ongudi indicated quite clearly that in as much as the PS in that case and Richard Dubai in that case were influential people, it is not enough to just see that they're influential. You must then be able to show how that affects. So are we going to use his position as a cross to crucify him? It is simple. The court can even warn him and tell him, please do not use your influence, do not interfere, do not do anything. He is a law-abiding citizen. And they say he might abscond. Yet when this matter started from 3rd of September in investigation, he has not run away. They arrested him on the 21st of this month. He did not move away, almost 3 weeks. How then do they imagine he's going to abscond? And in all these authorities that we have quoted, the courts have said that you must put material before the court to show that he has attempted to abscond or has prepared to do so. In the same authorities, it has said quite clearly that in case you are saying there's interference, you must show the interference. Is it direct or indirect, and how it has been done by the accused person. In the miscellaneous application, the court has also said that mere allegations that a person will influence investigations or interfere with witnesses is not sufficient. Material must be placed before that court. So what material do you have here? You're being told that the family has been threatened in that same paragraph. But look at that paragraph again, Neon, and I'll invite you to look at it. There is no OB number to show whether that has been reported, because when somebody is threatened, it is a crime. It has no date, it has no time. And this is an offense that is time specific. It cannot be looked at in any other way. We do not know even who the complainant is. So you're being told family. Who is family? Somebody specific must have been threatened and told specific words. If you do this or you do that, this will happen to you. That is what is a threat, not allegations. And you're being told in paragraph 18 that the intricate relationship between the accused person and individual confessions recorded by some suspects called Jackson, Otieno, Gombe. Does the prosecution forget that there is a witness protection program? Do they forget that that act exists? If that witness is vulnerable, why haven't they put him in such a position? Are those family members witnesses in this case? And yet you're being told that he has recorded a confession, and we shall be saying under Article 50, sub-Article 4, this confession is not a genuine one. It was made falsely, it was doctored. So if they say they have a confession, we are countering and saying it does not hold any water, and we'll be able to show in this trial. As I finish, my lady, Article number 19, you're being told, paragraph number 19, that if you release the accused person on bail, it will compromise the safety and security of the co-accused in this matter. Who are the co-accused? Because in this charge sheet today, we have only one accused person. Who are the co-accused? Let them not just make allegations. We must see who the co-accused persons are. They are not in this charge today, and that affidavit only mentions the accused person. How is then that a compelling reason? And you're being told that it is bringing up a problem, generating some anger, outrage in the county. What we have seen are people who are coming out with placards to support the accused person. They are saying, free the governor. He's an insolent man, he's a humble man, let him go. And that is the position we are also saying. So when they come out and tell you that there is outrage, when and where, please show that to the court so that the court cannot speculate, cannot imagine, must see the fact. And my lady, just so that you're being also informed that the accused person is at risk. It's the last one point, my lady. Is at risk of being maybe attacked or being injured, or he'll be at risk. His life is at risk. That's what the words they're using when he's in the county and all that. Ngetich versus Republic, 123 of 2010 at Nakuru, Justice Ouko, as he was then, said that it cannot be heard from the mouth of the state that a person is only safe when he's in custody. What are the other arms of government doing? What are he has his own security. Nobody has threatened him. They needed to show you that he has been threatened, or people have said if he comes, we will lynch him. That is missing. So when you look at these authorities totally, and when you look at Article 27, where we shall not discriminate against him because he's a governor, we start with equal footing, so that he is an ordinary citizen when we come before court. Today, he is not the honorable in this court. You are. For him, he's an accused person, and we start with equal footing like everybody else. So today, this affidavit does not give you compelling reasons. The contempt that it deserves, you will give it to it. That's all I wish to say.
I wanted to see a road there, I'm not seeing it. A park. We need it for air, because already I can hear it's too stuff. In fact, they should put them on one side so that we have what is happening. Yes. You said 40 minutes?
Yes. My lady, this is the order in which we prosecute our response. I'll deal with the grounds or compelling reasons for denying the accused person bond or bail. And my colleague, Mr. Muteti, will respond to the authorities filed by the applicant. This response, Your Honor, is supported by the affidavit shown by Mr. Clement Mwangi, Inspector of Police, and authorities filed in court. We have provided a list of authorities which we'll be relying on. Before I start our substantive response, Your Honor, I wish to disabuse some of the misconceptions and falsehood fronted by the applicant on a number of constitutional and legal issues. One, that the presumption of innocence is being violated by our opposition to the release of the accused person on bond or bail. Nothing can be far from the truth. Of course, everybody knows and appreciates that any accused person is innocent until proven guilty. That has nothing to do with bond or bail. Fair trial is contained under Article 50 of the Constitution, and nowhere does it state that the grant of bail or refusal of the same is a violation of the right to fair trial or hearing. The presumption of innocence does not mean that one may commit an offense, a grave one at that, at will, and brag that he is innocent until proven guilty. Secondly, Your Honor, Article 49 does not state that the right to bond or bail is an absolute right. Of course, my learned friend appreciates that neither the Constitution nor the CPC provides what is compelling reason, which may deny an accused person bond. This has been settled by a number of authorities from this court and outside jurisdiction. And we are going to demonstrate that fact. A third misconception, that the right to bail is inalienable right. That is not true. My lady, inalienable rights are contained under Article 25, and there are only 4. These are the rights which cannot be limited in any way and by anybody. And this is the freedom from torture and cruel, inhuman or degrading treatment or punishment. 2, freedom from slavery or servitude. 3, the right to a fair trial. And 4, the right to order of habeas corpus. This is not an habeas corpus. There is no allegation that fair trial has been denied, and therefore it is a misinterpretation of what inalienable right is. And we are going to demonstrate that this right, Your Honor, may be limited, just like any other rights other than rights under Section Article 25. The defense has alleged that the accused person has been tried and convicted by the media. That may be so, you are my lady, but this court has not convicted him. And the court considers only what has been put on record and is never persuaded or swayed by outrageous or outlandish comments by people and idlers out there. Therefore, this is not an argument for grant of bail.
Yeah, they agree.
For sixth, my learned friend, Mr. Obado, argues that this is a self-activating right and seeks to buttress that point by saying that exceptional circumstances may be found in a dictionary. With due respect, Your Honor, you can never find interpretation of law in English dictionaries or thesaurus. And that 7, by the court or the prosecution applying for limitation of this right is to terminate that right. That is also a falsehood, which of course I know the court will dismiss in the content it deserves. Courts have and continue to limit this right, and therefore that does not mean that the court has terminated a constitutional right. Nobody can be able to terminate a constitutional right, but the courts have powers to limit constitutional rights, except the right under Article 25. And this is not a matter of dignity. If it were so, Your Honor, then it will mean the indigent and poor people in custody do not deserve any dignity. Finally, it has been said that the prosecution has not provided evidence that the accused person is a person of influence. I suspect that my learned friend was not serious about it because every Tom, Dick and Harry knows the influence and stature of the accused before court. The people out there, outside this court. Now, Your Honor, I come back very briefly to highlight our response. Your Honor, I said, Your Honor, I've mentioned this, that what is compelling reasons to deny a person bond has been dealt with in a number of cases, and I'll only mention a few. Your Honor, I invited the court to look at our authority number 2, Milton Kabulit and others. That is 2011 EKLR. It's our authority number 2. Yes, you are. Yes, it's at the top. At the top of we had already supplied a copy. If he wishes to enjoy himself, I can give him a copy which I have. This decision of the High Court is of course persuasive, and we will be urging the court to be persuaded by this decision. And at page 20, at page 13 through page 16, the court isolated a number of reasons that will be deemed to be compelling reasons to deny the person bond. And may I point this, my lady, from the beginning, that the right to bail is not absolute. It is one of those rights which I said may be limited if there exists compelling reasons or circumstances. And the factors that may be considered include the nature of the right or fundamental right, 2, the importance and purpose of the limitation, the nature and extent of the limitation, the need to ensure that the enjoyment of the rights and the fundamental freedom by any individual does not prejudice the rights and the fundamental freedoms of others, and the relation between the limitation and its purpose. And at page 15, the court, drawing from the decision of the Supreme Court of Nigeria in the case of Alhaj Mahid versus Federal Republic of Nigeria, cited a number of reasons for declining the grant of bond. As one, the nature of the offense. I would not emphasize the nature of this offense before this court. Number 2, the strength of the evidence. The defense appeared to diminish this factor, that even if the evidence is overwhelming, so what? Yet, it is a factor to be considered. The gravity of the punishment. Of course, we do not wish to emphasize that this offense carries the death penalty if convicted. Then the likelihood of further charges being brought against the accused. And fundamentally also, the likelihood of the accused interfering with witnesses or may suppress any evidence that may incriminate him. That is our submission, that the accused here is charged with a grave offense or charge. He is a person of influence and is likely to interfere with witnesses. And in our affidavit, Your Honor, we have said that some of the witnesses are from the county government of Migori. Where the accused person is governor. The other authority, Your Honor, which I will not seek to read, is the decision by your brother judge Fred Otieno, the case of Father Republic vs. Father Guyo Wako. That's our authority number 3. My lady, there was a mistake. We had attached the different, actually wrong ruling, but I've annexed. It's loose in the bundle, and I've also applied the same to the defense. The judge also looked at what may be compelling reason to deny the person bond. And one of the reasons which my learned friend appeared to belittle is the gravity or severity of the sentence if convicted, and also that confessions had been made. We submit that these are critical considerations in denying a person bail. Your Honor, we also depend in our affidavit that there are threats and intimidations which may dissuade or scare away some of the witnesses. In our list of authorities number 4 and number 8, we submit, Your Honor, that such are considerations which the court must take into account when deciding whether to release a person in bond or not. And in the authority number 4, Your Honor, if I may refer it briefly, the case of Diana, Suleiman, and another. This is a case where the accused persons have been tried for murder, and they made application for release of bond. And the court considered the balance of the individual rights vis-a-vis the public interest. And that's at page 6. This is what the court said. The issue of public interest in national security and the public safety as a matter of compelling reason in the consideration for bail is incontestable. In fact, the court will be surprised that the defense is contesting this fact, based both on the spirit of Article 24, limitations in the interest of others justifiable in open and democratic society. When national security and public safety are threatened, the very existence of the open and democratic and civilized society is also jeopardized. It must then become a matter of proper balance between the individual rights and the rights of the society, so that the individual is entitled to enjoy the greatest extent of his rights, consistent with the rights and interests of others of public interest in the particular matter. Your Honor, it's now a matter of public notoriety. This heinous crime of murder is becoming current. The other day it was Sharon. Shortly thereafter it was a baby, a kid in Meru. Hot on the heels of that was a case in Machakos. Even before the body could get cold in that one is the case of Kilimani lady who was also murdered in cold blood. So these are things which the court must consider, that these issues are gaining currency, and the urge of suspects to try and cover their trails is very, very critical in this if the accused person was to be released from jail. As I sit, Your Honor, it is important to understand the circumstances under which the deceased was murdered and the unborn baby also killed. She was lured into a trap of people closely associated with the accused person.
Yes.
That is our...
We want to object to that line of argument. I think now counsel is testifying. He does not have all that in his affidavit.
I want to suspect that my learned friend has not looked at the affidavit. Paragraph 19. 7, 8. It's there in the affidavit. Of course, I know Ms. Obado started from paragraph 10. And may have lost the other counsel. We have deponed to that. And when a person lures, when a person... Your Honor, from paragraph 1, from paragraph 4 to 9, 4 and 5, and then 7 and 8. Of course, that is our evidence, which we present before this court, but
Our that objection is not there.
That I would abandon that line. But in sum, my lady, what I am submitting is that we have demonstrated that there are compelling reasons for denying the accused person bond. And my learned friend, colleague Mr. Otieno, will now respond on the authorities handed over by the applicants. We have 16 minutes. Yes. I'd like, of course, the court to find time to look at the authorities we have submitted. And the defense, sorry, the counsel for the
family
watching brief for the family, they have said if we run out of time, they will donate their 5, they remain with 5. Thank
you. We are already married to the net.
Yes, my lady, allow me to begin.
I want to see that part so that we have some air flowing. Mr. Mutete, you have 16 minutes.
Begin with the preamble of our Constitution. My lady, the people of Kenya committed themselves to nurturing and protecting the well-being of the individual, the family, communities, and the nation. That is a loaded statement collectively stated by the people of Kenya. And in the arrangement of the Bill of Rights, again realizing the importance of human life, the first right is the right to life. Article 26. My lady, that emphasizes the need to protect human life by all means, by the state and all its actors, and non-state actors as well. Article 26 sub Article 3 expressly states a person shall not be deprived of life intentionally except to the extent authorized by these constitutions or other written laws. 2 lives were lost here. But we are not only talking about Sharon, but also an unborn baby who is protected under Article 26 sub Article 2, because life begins at conception. 2 murders. That, my lady, yes. Thank you, my lady.
The information is before the court.
My lady, fortunately we saw that danger and annexed the 2 postmortem forms to demonstrate that fact. It's not a statement from the bar that we are making, but it's a fact that there were 2 lives, and the postmortems are next to our affidavits.
The charge sheet is one, and the issue of unborn child is not in that charge sheet, so it's relevant.
My lady, our annex is evidence, and certainly we will go that direction at some point.
Okay, let's deal with what is before
Yes.
the court.
And my lady, I was just going to touch on these 2 annexures to our affidavit. The postmortem, just to demonstrate the gruesome nature. This murder was executed. It is the kind of a murder that would shock the conscience of men by the injuries that you will note from these 2 postmortem forms. That is stated to underscore the gravity of the offense as a consideration when this court addresses its mind to whether or not to grant bail. Lady, Mr. Cliff Ombeta has relied heavily on the decision of Dwight Sagarai, that is the first decision in Obado. And I invite you to look at paragraph 20 of that decision and look at it together with paragraph 14, subparagraph 1 of our affidavit. Proof of interference with witnesses, that is what the decision states. Proof of interference with witnesses at paragraph 20 are not only varied, but include both direct and indirect interference. That is not us, it is the court speaking. And the decision goes further at paragraph 21, right at the middle. And my lady, the court states, there is need of further proof that will demonstrate a real existence of likelihood that witnesses have or are likely to be interfered. For instance, and I emphasize this part, for instance, the evidence that the 2 witnesses will remain in accused employment. That is important to us, my lady, when you look at paragraph 14, subparagraph 1 and 3. Some of our witnesses fall in the category that the court had in mind when making this decision. Further down, at paragraph 35, looking at other jurisdictions, the court cited the decision of Ahmad Muhammad, which is a local decision here. And I invite you to look at paragraph 35A and E. A addresses the question of safety of the public or any person. Our affidavit addresses the question of the safety of the family of the deceased, witnesses, and persons resident in Migori County. Paragraph E, my lady, deals with exceptional circumstances where there is a likelihood that the release of the accused would disturb public order or undermine public peace and security. Again, that is not an idle statement. It is backed by our affidavit at paragraph 21 that the situation in Migori County is potentially explosive. That has not been discounted. My learned friends had a very good opportunity to ask that the deponent takes the stand, they cross-examine and rebut that statement. My lady, in the absence of any such rebuttal, in this court should be pleased to treat that as the truth and nothing less. Again, the court in this same decision at paragraph 37, while granting bail, stated that it may be important that the prosecution, the last line, to prove that he is such a public figure that arresting him may lead to chaos anywhere in Kenya. Again, that goes to the previous point that I've dealt with. All these things were absent when my lady, you sat in judgment and delivered that ruling. I urge you to find that that decision is distinguishable and cannot apply to the present circumstances.
5 minutes.
5 minutes, yes, I'll finish. The second decision in Obado, that is the case of Julius Mandeli Mwangi. Again, this is distinguishable. At page 2 of that decision, the investigating officer who came before court simply assisted the defense. You will find that at page 2, paragraph 3, and the judge had no difficulty granting it. Over, my lady, to the case of Danson Mugunya. Again, undistinguishable authority. More than 10 witnesses in the last page, second last page of the decision. More than 10 witnesses had given evidence. And at paragraph 3, the judge says, as a result, all the ordinary wananchi witnesses, and he uses the word wananchi witnesses, have testified. So in his assessment, there was no threat or likelihood of interference, because all those who remained were officers. That is not the position in our case. But let me finally, the question of witness protection that has been really amplified. In our humble submission, Witness Protection Act was not intended to uproot law-abiding citizens from their homes to witness protection safe houses. Merely because somebody wants to enjoy their right to liberty when they are accused of having taken a life. Lady, I urge you to find that is not the spirit, and it's not in all cases that people have to be removed from from their rules. Finally, on the Ngetich decision, that is decision, I think the second last decision by my line friend, Mr. Clifford Better. It may be well that one cannot say the state cannot secure with the public, but would the court then sit and close its eyes to obvious danger? Because the state also includes the court. The court has a duty to protect the citizens, to uphold the rule of law, and counterbalance private interests against public interest. I urge you to find this is a fit case where the accused person should be patient enough at this stage, and you decline to grant bail. Finally, bail can be revisited at any other stage. It need not be done at the seminal phase of a trial. With that, I urge you to dismiss the application and find no merit. That's all.
My lady, good afternoon once more. On the side of the family or the victims in this matter, my lady will be supporting the prosecution entirely with its submissions. We are humbly urging this honorable court, my lady. We did it. We didn't try.
Yes.
My lady, we are urging this honorable court, when it will retire to make its ruling, to involve a balance of rights of an accused person and the rights or the sacrosanct right to life. My lady, we are before you on no lesser charge than murder. My lady, the offense is grave and complex. The prosecution have said that, the defense has said that the accused is ready to abide by all the court orders and is likely to attend the entire trial. However, the court should take into account that justice should not only be done, but it must be seen to have been done. In relation to that, I'm trying to allude at a point that the court should take cognizance of other issues, like is there a possibility of an accused person in this matter tampering or interfering with witnesses in this case. My lady, it is common knowledge that all the witnesses in this matter are subjects of the accused person.
My lady, I'm not so sure where we get that common knowledge from. I just want to remind my colleague that he doesn't have an affidavit. Let him just stick to points of view. That knowledge is just his. We don't share it. Give him evidence.
My lady, I have a few minutes.
The committal bundles supplied. So he's saying you're the only one who shares that view.
Very well. We stand guided. We stand guided. We stand guided. We stand guided. My lady, by denying the accused person's bail, does not infringe on the constitutional right of the accused person. The right under Article 49(1)(h) is not absolute. The court has the power and the discretion to limit such a kind of right. And in so doing, we will be urging this court to deny the accused person in this matter a right to bail. That is all. My 5 minutes are up.
Then it's okay. Yours are how many? 10?
My lady, perhaps straight.
No, you have 10 minutes.
I will. I have had counsels, my colleagues from the prosecution and those watching it from the family. It is clear to me that what is before court today is a thesis it is clear to me that what is before you today is a thesis of the grounds in which to grant bail or decline to grant bail. The Constitution is clear that there must be compelling reasons for this court not to grant bail. Several authorities have been addressed on what compelling reasons is. And I refer court to the case of Republic versus Guyo, which cites the case of David Njuno Mbiu versus Koinange. The court describes compelling reason as forceful and powerful. Now, what my learned colleague has gone through an authority with several reasons that this court must not grant bail. The first two is the nature of the offense and the punishment for the offense. Irrespective of the individual that has been arrested, the nature of the offense and the punishment is standard for all such murder cases. And our Constitution allows for bail irrespective of that nature and the sentence. We move to the strengths of the case. We do not have committal bundles issued in this court. There's no witness who has taken up the dock, and there's absolutely nothing before this court on the strength of the case. He talked about likeliness of further charges. There's absolutely no demonstration in the affidavit in this relation. And even if a further charge is to be preferred, that is a case that the court will deal with on a basis-to-basis case. It's talked about a confession. We have no co-accused in this particular case. We have no confession, my lady, before this court. Mr. Dari did not resist the temptation of talking to the public gallery and talks about several other murder cases all over the world. I'm not so sure if that is to, all over the country.
We are also addressing the gallery.
All over the country. My lady, every case must be dealt with in its own merit. And there's no relationship between this case and all those that he cites. My lady, on the ground of influence by the accused person, it is not sufficient to demonstrate that he is a governor. And all the possibilities that a governor could do. If we were to go on speculation, surely the sky would be the limit. What have they said that he has done so far or attempted to do? Zero. And as far as interfering with the investigations or witnesses. The offense was committed on the 3rd of September. The accused before you was arrested on the 21st of September. He was a governor all that while, he still is. And the prosecution do not demonstrate a single thing he did or attempted to do in that relation. There's a general allegation that the family of the deceased has been threatened. The good deponent carefully does not say that this was done by the accused person before you. Or for that matter, say by who, when, and where. It's a paragraph completely not substantiated. contrary, in paragraph 10 of his affidavit, he deponds that he's cooperated with the prosecutors, with the investigators in every way that they have sought. In paragraph 11, he also reiterates.
My lady, I'm going to object to that line of response. If the defense realizes they forgot to say something when they were presenting their case, we have not analyzed.
It's okay, let's not waste time. You answer what they have said.
My lady, that's fair. They have talked about interference of witnesses without substantiating. In paragraph 11, the accused person deponds that he has not interfered with any witness and is not intending to. My lady, in that regard, Article 27(1) gives equal protection and benefit of the law. We also invite you to invoke Article 159, subarticle 2A, which grants justice to all persons irrespective of their status. On concluding that point, Article 160, subarticle 1, invites this court to be subject only to the Constitution and the rule of law. My lady, on witness protection, may I just ask for 2 minutes? I'll put my eyes on the floor. The issue of witness protection, we reiterate that there's a provision in the Act and the institution, and more important, there's no demonstration at all that there's any that has been threatened. Let alone by the accused before you. They also talked about threatening of co-accused. We have none before you. My lady, and as I conclude, in the issue of public order and national security, in paragraph 21, the deposition is that there is potentially the situation would get explosive. Potentially. All these investigations have been happening in Homa Bay and Migori. There's been no riot. There's no report by the police or intelligence or any OB of any public insecurity or disorder. So, lady, and I want to rely on the authority, your own authority of Richard David Alden, on the proof that the prosecution should give.
I'm not able to understand. Is this the time to submit their authorities when they should have done that when they are making their
An authority is a point of law.
No, I said, if you've forgotten,
No,
you
you
forgot
touched it. We touched on it, and authority is a point of law, Mr. Dan.
No.
Just allow him to conclude. Can you just conclude?
My lady, Mr. Oyoro urges this court that justice must not only be done, but be seen to be done, and urges this court to deny bail. He clearly has tried this case, convicted the accused, and truly believes that denial of bail is the punishment.
Where you are rattling? Why do you want to do that?
I appreciate the indulgence. We humbly apply for bail, Malady.
So I will ignore the thing that he has convicted and sentenced or whatever it is.
Malady, let me just conclude by reminding you that there is a presumption of innocence. This case is yet to be tried.
It's not a presumption, it's actually a right.
In fact, denial of this right without a compelling reason is what would infringe on the accused constitutional right, most of much.
You are becoming academic as your friend. Now, I think yesterday you mentioned about the matter coming back before the court tomorrow.
No, the matter, I think we are done with this. What we have tomorrow is a different matter, which the court has given some time for the accused to be brought back tomorrow.
So this one is not coming back tomorrow?
No, this one, we have not so far consolidated the cases, so we'll be awaiting the ruling of the court. The case coming up tomorrow is for somebody else, of course related to this case.
Your lady, Mr. Ondari, seems to have selective memory. Yesterday he said on Wednesday we are going to consolidate this case with the other one. So when you ask whether the matter is coming, yes.
Because I thought you talked about
yesterday we said, may we argue this application tomorrow, on Wednesday, when we hope to bring the other accused person. The court ruled that no, this is a separate case, let's deal with this case. Each case will be dealt with.
What you said?
Yes.
We have another matter coming up on Wednesday related to this one.
Yes.
So you are saying the earliest we can argue the application was Wednesday. In the meantime, we asked okay, that has nothing to do. But you are talking about consolidating.
Yes.
So you have no intention of consolidating tomorrow?
We shall when we take plea. We are applying for consolidated. But what is before you all is a bail application. And
there's a reason I am asking that. So
we will be bringing some other people tomorrow related to this case. And if it pleases the court,
it's not coming tomorrow. That's all I want to find out. It's not coming up tomorrow, this one.
No, there is no
okay.
All of that is unless, of course, the court wishes or they request that they want to come tomorrow.
The issue was consolidation. So if there is no consolidation, it's okay. Getonga.
What perhaps maybe what I perhaps conceive the court to say is that we are going to argue another application tomorrow.
I'm asking about consolidation of this with another because that was the indication you gave.
We shall be at the opportune time when we will all be.
But now not tomorrow.
Not tomorrow.
We want to make very lengthy submissions tomorrow absent Obado.
This Thursday.
Most of the night. What? 8? What time?
It will be 2 o'clock.
Most of the night. We wish to notify the court that we have an alibi, which we will be filing on 27th.
Okay, you can file any time, there's no problem. But there's something we are calling retire conference.
Yes.
And that's when you can bring all those things. Yes. And I think on Thursday we should settle on a date for that. But if it's going to be consolidated, then we have to wait until the matters are consolidated. And then you can do a pre-trial for all of them.
Very well.
Yeah. So 27th in the afternoon, where is the accused person? I cannot see him. 27th at 2 o'clock we come for Yaru. What is adjourned?
Hapa mwelekeo sasa ni kuwa gavana Obado itabidi angoje hadi siku ya Alhamisi tarehe 27 ili aweze kujua uamuzi ambao koti itatoa kuhusiana na ombi lake la dhamana. Kwa hivyo kwa sasa ni kuwa Obado atasalia katika kituo au gereza la Industrial Area hadi siku ya tarehe 27, kumaanisha ni siku moja kutoka leo, ambapo uamuzi utafanywa rasmi kujua ikiwa atapatiwa ombi lake la dhamana la kufanya ama kufuatilia kesi hii akiwa nje, ama atakuwa akifuatilia kesi hii akiwa katika mikononi mwa maafisa wa usalama. Kwa hivyo ndio hali imekuwa, kumekuweko na vuta ni kuvute katika koti kutoka kwa mawakili wa utetezi na mawakili wa upande wa utetezi na ule mwingine ambao wamekuwa wakipigania swala hili la ombi la dhamana. Utakumbuka kuwa jana Obado ambaye ni gavana wa Migori aliweza kukana rasmi kuwa hakuhusika katika mauaji ya Sharon Otieno, ikiwa ni mojawapo ya kesi ambazo zimekuwa zikiangaziwa zaidi, kesi za ngazi za juu kuhusiana na mauaji ya Sharon Otieno yaliyofanyika Septemba tarehe 3. Ni hali ambayo imekuwa na masuala mengi tu siku hii ya leo. Kumekuweko na watu mbalimbali ambao walijitokeza, wananchi wakifika eneo hili katika ile hali ya kufuatilia mkondo wa kesi hii. Ni kesi ambayo kila siku ama kila uchao imekuwa ikichipuka, ikiweza kuwa na masuala tofauti. Tumekuwa tukiona kila siku tunajua mambo mapya ambayo yanajitokeza katika kesi hii, na ni kesi ambayo Jesse Lesit ambaye ni jaji wa mahakama ya juu amekuwa akishikilia na atashikilia usukani huu hata katika siku zijazo. Na muhimu sasa ni kujua ikiwa ombi hili la dhamana litaweza kutolewa. Baadhi tu labda ni kupatia semi ambazo zilitoka kutoka kwa mawakili ambao wanawakilisha upande wa Obado na upande wa serikali. Mawakili wa Obado wamekuwa wakishikilia kuwa ni haki yake ya kimsingi na haki ya katiba kuweza kupatiwa ombi lake la dhamana, wakisema kuwa kipengee 49(1)(h) cha katiba ya Kenya kinaruhusu kuwa aweze kupatiwa haki yake ya kimsingi ya kuweza kupatiwa dhamana. Lakini wakati huo upande ule mwingine wa utetezi umekuwa ukishikilia kuwa ni haki ambayo ama ni wajibu wa ambaye ni ule jaji JC Lesit kuweza kutoa uamuzi mwafaka kuhusiana na hili, na kuwa si kawaida tu eti aweze kupatiwa moja kwa moja aweze kupatiwa dhamana. Wamekuwa wakisema kuwa akiachiliwa huko nje huenda kwa njia moja au nyingine akajihusisha na kesi hii, na vile vile kuweza labda kuwatishia wale ambao wanatarajiwa kuwa watakuwa katika kesi hii. Kwa hivyo kwa njia moja au nyingine wakasema kuwa haitoshi kuweza kumwachilia huko nje, na wale wengine wa upande ule mwingine wakasema kuwa akaachiliwa nje itakuwa ni haki yake ya kimsingi, kwa sababu hii itampatia nafasi ya kuweza kutangamana na mawakili wake na kuweza hata kutathmini kesi hii kwa mapana na marefu, ili waweze kupata mwafaka ama haki iweze kupatikana. Lakini kimsingi ni kuwa Wakenya wanatizamia kuwa mahakama wakati huu itaweza kutoa uamuzi mwafaka ambao utaweza kuhakikisha kuwa haki imepatikana. Sharon Otieno alipouawa tarehe 3, familia yake imekuwa ikilia majonzi ikisema kuwa sheria ni lazima iweze kupatikana. Yule mtoto mchanga ambaye angezaliwa miezi 3 kutoka sasa kitambo amezikwa, lakini Sharon Otieno bado hajazikwa, familia ikishikilia kuwa haitamzika mpaka waweze kupata majibu haswa ya ni nani ambaye aliweza kumuua. Kwa hivyo kwa hayo na mengi ambayo tumekuwa tukikuletea, tunaweza kushukuru kuweza kuwa na sisi KTN News, na tutakuwa tukirejea tena mahali hapa katika mahakama ya Milimani tarehe 27 ikiwa ni siku ya Alhamisi. Kwako ni Kwambua.
Na asante sana Francis Ntumwa, bila shaka kwa hiyo taarifa kutoka mahakama Milimani. Mtazamaji, kumbuka kwamba upande wa bado wamekuwa sana wakisema kwamba kumnyima dhamana basi ni kukiuka haki yake kama Mkenya, na upande mwingine basi upande wa mashtaka wanasema kwamba kunyimwa dhamana kwa Obado basi hakukiuki haki zozote za bwana Obado, na hivyo upande wa mashtaka wanataka kwamba hii kesi iendelee wakati yuko rumande. Kwa hivyo ni hadi siku ya Alhamisi ambapo tutakuwa tunaendelea na hii taarifa kuhusiana na ombi la Obado, gavana wa kaunti ya Migori, kupata dhamana. Basi kufikia hapa mtazamaji, naomba nipate mapumziko, lakini muda si mrefu nitakuwa narejea tuweze kupasha mengi zaidi ambayo tumekuandalia siku ya leo